Yeah, so today we'll be learning about civil pleadings and the initial stage. Like we'll be seeing that how a plaint is drafted, then how a written submission from the defendant side is drafted, and then how a rejoinder is drafted. So basically, we'll see that from what source and what provisions of law is applicable when it comes to drafting about the plaint written submissions, and then how and what all things we actually include in a draft. And we'll also see the samples of plaint and written submissions and how do they actually look. Okay, so I'll start sharing my screen. Just a second. Okay. Yeah. Okay, so is my screen visible to all?
Yes, ma'am.
Okay. So earlier we know that what all criminal cases and how they differ from civil cases. So in civil cases, there are a variety of cases which come, such as if there is any breach of contract, or there is any recovery suit, or there is any damages suit, torts, rent, everything comes in civil cases. So whatever is not criminal, it comes under civil cases. So there is this statute which is known as Code of Civil Procedure, and the acronym for that is CPC, which we usually call like CPC. So this is the main statute from which we get all the proceedings regarding, like it regulates and it has the provisions regarding all the proceedings of in a civil court. So where we are when we draft a plain, when we draft a written submission, that is not drafted randomly. The basic rules of how it has to be drafted, how these documents have to be submitted to the court, all these come and emanate from this particular statute, that is Code of Civil Procedure. So basically, we'll start. So it also lays down some rules for drafting and plain, but it may be seen that in different jurisdiction, like in different states, there are some different unique rules they have. The we can say the style of these pleadings may differ from jurisdiction to jurisdiction, but the basic features of what a plain should has or what a written submission should has is uniform everywhere in entire country. So the basic rules come from this statute only. It may differ state wise, but then the basic things will remain the same. Okay, so now when we have a problem or we have an issue with someone and it comes under civil case, the first thing and our first interaction with the court, the first thing which we take in account is what we do as a step is we may send the other party a legal notice. Okay, and you have seen legal notices in your last class. So basically what we do is before going to the court, we send a legal notice to other person that, see, I am having this and this issue with you. If you are not going to resolve this, I am going to court and I will initiate a civil proceedings against you. So, and if we are not getting a positive reply and our grievances are not being heard properly, then what happens is that we now file a complaint in the civil court. So this complaint, like this plaint, is basically the first and the initial step, and this is the first time we are communicating our grievances to court. That's the this is our problem, and this is what we want from the court. So this particular document, which is the first document which we file in the court, explaining what all problems we have, is known as plaint. Okay, so plaint, so we'll see that how a plaint is drafted, what are its features. If we see CPC, we have to go to order 7. Okay, order 7 deals with uh, yeah, so basically order 7 deals with, so CPC consists of sections and orders. Order is most of a, like it consists of most procedural things what we have to keep into account while we are going forward with our draft. So if you can see here, this is order 7, and it explains what a plaint is and what particulars to be contained in plaint. So if we see that what all it constitutes, we can see that plaint shall contain the following particulars. Number first is the name of the court in which the suit is brought. Of course, like wherever you are filing the case, you is, am I audible to all? Hello, am I audible to all?
Yes.
Yes, ma'am.
Okay, there was some network error. Okay, so basically, when we see that what all things should be constituted in like what should a plaint contain, number first is the name of the court in which the suit is brought. Okay, Second is the name, description, and place of residence of a plaintiff. We all know what a plaintiff is: a person who is instituting the suit and who is having complaint against the other person, and the other person whom we are suing is the defendant who has to now defend his case. So when a plaintiff files a plaint in the court, so they have a plaintiff has to give the name, description, and place of residence, and also the name, description, and place of residence of the defendant also. So basically, it is very, very important in a plaint. Some basic rules which you always have to remember is that everything should be very certain and very clear. So when you are saying that the name of a plaintiff is Mr. Manoj or the name of defendant is Mr. Ram, then there are thousands and crores of Mr. Ram. You have to explain that where they live, what is their description is like, what work they do, and what is the place of residence, so that you can be certain enough that you are not suing Mr. Ram or so of so colony, but you want to sue Mr. Ram of such and such colony. So you have to be very certain throughout your, whenever you are drafting any pleading, and it is a rule which is applicable in all the types of drafts which you do. Very certain you have to be while you go about it. Then we can see that plaintiff or defendant is a minor or a person of unsound mind, a statement to that effect. You have to like just give the acknowledgement to this. Then there are some very important things which you have to contain in your plaint. So whenever we file a plaint, we of course we are taking an action against that. So we have to explain the cause of action. When we say what a cause of action is, it means that such facts which you are going to take, and such facts which prove that you have an action against it, and this is the default of the plaintiff. So there comes a cause of action, that why, what is the reason you are here in the court, what is the cause of your action. So you have to describe all those facts which actually help you to blame the defendant. That's it, these are the facts which say these are the facts which I am contending, and because of these facts I have an action in law against the defendant. So you have to very clearly mention that what your cause of action is. Without cause of action you can never go to court. If there is no reason you are why you are coming, then the court will never entertain it. So just remember that in a plaint you should have a cause of action. Then second is the fact showing the court has jurisdiction. So we all know that the power to hear a case is known as jurisdiction. So this is also determined. So when you get a case in hand, that okay, this is the case, you have to determine that which court am I supposed to go and file this case, what will be the territorial jurisdiction, what will be the pecuniary jurisdiction. So we are going to take a elaborate class on jurisdiction aspect also, but just for the sake of drafting, we there in CPC only, from section 16 to section 21, you can see the provisions of jurisdiction, that where and in which conditions you go to which court. So when you are starting a case and you're filing a plaint, you should be very clear that okay, the amount included in my problem or in my case is such and such, and maybe I reside at the defendant reside here, and that's why the cause of action arise here. So all these factors together tell you that which court will be the most suitable court to file your plaint, and that we'll discuss in detail later on. But you should of course be very clear about the jurisdiction, and that's why only you can go to the right court. Okay, so and then other important thing is the relief which you want from the court. You cannot just go and state random facts in front of the court. You have to be very clear that actually why you are here, what is like, what relief do you want. So you have to be very clearly mention that prayer. So there is a prayer clause in every plaint, and then you have to mention that, see, this is my prayer, and you have to elaborate on that, that specifically I need this from the court. Okay, so then there is other thing, that where the plaintiff has allowed a set off or relinquished a portion of his claim, the amounts were allowed or relinquished. Okay, so this are certain conditions where if the plaintiff has allowed a set off or relinquished a portion, which means that if the defendant is also having some claim against the plaintiff, so what plaintiff can do is plaintiff can set off that amount, which means that whatever plaintiff has to pay back to defendant, it will reduce that amount, and it has to state in front of the court that, see, I owe the defendant this and this amount, and that's why I am giving up on this claim, but I have certain other claims against the defendant. Then some other important clauses, that whatever subject matter is involved in your case, say that there is a property dispute where you want so there is a dispute regarding the sale of an immovable property. So then it is very important to state that the immovable property which is involved in your dispute, what is the value of that subject matter? Okay, so this value of subject matter is very important because this decides your jurisdiction also when it comes to the pecuniary jurisdiction, and this also decides that how much court fee you have to give. So whatever the subject matter is there in the suit, you have to determine the value of it. You also have to mention that in your plaint. You also have to mention the court fees, that how, what court fees have you paid the court fees, or you didn't pay this, so you have to mention that I have paid the court fees in your plaint. Okay, so this was all about plaint. Like these are the particulars which we see in plaint, and there are so in order 7 you can go through it later and you can see what all other provisions are there. So in money suits, and then there are different provisions that relief to be specifically stated. As I told, relief founded on separate grounds, you have to be very certain enough to like mention all these things in plaint. Okay, so now we understood what a plaint is. Do you have any doubts at this point? Any doubts, guys?
No, Di.
Not as of now.
Okay, so now we'll see a sample of a plaint. Okay, how this plaint actually looks. So now we have a suit for declaration and permanent and mandatory injunction. So what is actually this is basically when you are restricting someone, or when you require the court for a direction to either direct something to the defendant or either restrict the defendant to do something. Okay, so basically this is a property suit where I want the court to declare that this property is mine, and I want the court to tell the defendant that listen, just this is not your property, so please vacate this property, and you don't have any right over this property, as this property is of the plaintiff. So I have come before this court and I have filed this suit for declaration. So now we'll see that how a plaint is drafted and how it actually looks. Okay, so as we start here, the first line will be, of course, that what before which court we are coming. Okay, so these two lines in the middle will be like where we are coming, and what before which court we are coming. Then there will be a civil suit number. This number is granted to us by the court, so we have to mention this civil suit number every time while we are drafting a claim. Then the third line comes in the matter of, okay, in the matter of plaintiff and defendant. So here one thing is missing. You also have to, so here only, so basically there are two different things. Now what you can do is you can also file a memo of parties before the actual plaint begins. Okay, so in the memo of parties, you can give full description of party. So Tanvi P, where she is residing. Okay, what is this? What is her full name? She is the daughter of who and who. So this you can give in the memo of parties. But when you are not giving a memo of parties and there are on one part. Hello.
Yeah, I was just so क्या आप कोई सैंपल शो कर रहे हो क्योंकि मुझे नहीं दिख रहा है.
Okay.
Yes, the format is not visible.
Oh, sorry. I thought it is visible. Wait, I'll just share my screen once again. Okay, I'll share it once again. Okay, is my screen visible now?
Yes.
Okay, so basically, yeah, so what I was telling is that this we write the court's name and address, that's before the court of senior civil judge. Then we write civil suit number. This number is given to us, we allocate this number and we have to mention it on our plaint. Okay, then third thing comes is in a matter of, and we have to write the plaintiff's name and defendant's name in this way only. What is missing over here is, as I mentioned, that the plaintiff and defendant should have full name, full address, and if they, and the description such as they are son and daughter of or wife of, something which like really tells that okay, this is this particular person. So there are two ways of even doing that. When there are a lot of plaintiffs and a lot of
Date
defendants,
of birth is also necessary.
No, date of birth is you can write the age. Yeah, age is necessary, but like not particular date of birth, but age. Okay, so in this case, what happens is like when there are a lot of plaintiffs and defendant, what we do is we attach a memo of parties in the beginning, and in memo of parties we mention all those descriptions, and in the plaint we write like this. However, when there are one or two members only, we describe everything here only. So from here, it is missing. We'll see it in another draft when we'll go through it, that how we actually write it. So basically, after Tanvi P, you can write aged this and daughter of this, something like this. Okay, what am I? Yeah. So daughter of this, and then the resident of this. If there is any company, you have to mention that this company registered under Companies Act 1956 with this registered office at this. Only 2 lines description, that is enough. Then we come here and we put the subject. Subject can be a plain file under, so this is like suit for declaration and permanent mandatory injunction. It can be a suit file under order 7 rule 1, which we have seen the plain. So we can give the provision that order file under rule 1, order 7 rule 1 for such and such reason. Now other when we come down, so it's like most respectfully short, so we write this and then we start from our paragraphs, like what we actually want. So now there is a specific, not specific, but this is what is preferred, and this is what will make your work easier as well as a judge's work easier when you will go according to this, when you will draft a plaint. So the first thing, when you are the very first paragraph of the plaint should be that for what this plaint is about. Okay, so when you just think from a judge's perspective. If you start from randomly laying down all the facts at once, and the judge has to go through the entire facts to just figure out that why are you here in the court, then it is very tedious for a judge, and even the judge will not appreciate such kind of draft, right? So what we have to do is, in the first para, we are going to summarize it in 2 lines, that for what actually we are here. So we can write like this, that this present suit is being filed against defendant. Okay, herein seeking declaration that the property is owned by plaintiff and subsequent relief or permanent injunction is asked. So what we did is, in the first paragraph itself, we have cleared our case, that see, we are before this court and we want to seek such and such thing from the court, and that's why we have filed a case against defendant. So this is one thing which is really very important, that in the first paragraph you are straight away telling the judge that see, we want this. Then second, when we come to the second paragraph, the second paragraph should contain the details of the plaintiff. Okay, I'll show you another basically I'll show you another draft also, how we actually go about it. Just a second. Okay. Okay. So now you can see this. Is it visible? Okay. Can you all see this?
Yes.
Okay. So see, what I told you is, like, we have described here that she's he's a resident of so and so. Then this is actually a consumer complaint. So even you can see that the consumer complaint is also basically a civil suit only. So this is basically a consumer complaint, which is also which also follows all the particulars of a plaint. So what we say is under section 2C read with section 1112 of Consumer Protection Act. So though it is being filed under Consumer Protection Act, it will utilize and it will follow all the features which is actually given into CPC. So we see that here in the first paragraph, again, what we did is we just described that for what our complaint is filed. Then the other important thing is, we are in second paragraph defining that who is actually the plaintiff. You have to, in second paragraph, you have to give the details of the plaintiff. So you can see here what it is given, that the complainant is an engineering student pursuing so and so thing from Mumbai. He is a resident of so and so. Okay, now this is a little bit about him, that what he actually does. So just for informing you, say I am a businessman, the plaintiff is a businessman, and the defendant is also a businessman.
Your voice.
Am I
Your
clear?
voice is.
Okay. So am I clear now? Is it clear?
Yeah. Now it is clear, but before Oh, it was very much slow.
Okay, 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 okay. So I'll repeat what I said. Basically, I was telling that in the first paragraph, after telling that what this suit is about, in the second paragraph, we actually define a plaintiff. Say that the plaintiff is a businessman. Okay, I have a showroom of maybe I have a showroom of furniture. Okay, so when in second paragraph, I will define myself that the plaintiff is the owner and is the businessman and he owns a showroom in such and such place. He does business of furniture, or like he's as if having a wholesale business of furniture. Then what you have to do is you have to show the court that see, the plaintiff is very generous and the plaintiff is very honest and plaintiff is known for his business ethics. So there may be a thing where the plaintiff is suing the other defend. It also varies case by case, but I'm just giving you an idea that this is the paragraph where you have to say that see, this is the job profile of the plaintiff, and this is how the plaintiff is very well known and his goodwill is there and he's very generous and honest. So you have to write all those things. If you will write all those things, it will increase the credibility of plaintiff. Then in the other paragraph, in the next paragraph, say the third paragraph, we are going to define the defendant or the opposite party. So we see here that the opposite party is a flag carrier airline in India. It is a government owned company incorporated. It opened fleet to Airbus. So basically what we are seeing that how we are describing the defendant. So in the third paragraph, you have to do that. You have to clearly define what the defendant actually does. What is this? Now, from the fourth paragraph, you can start enumerating your own facts. Okay, we see that what all problems did the plaintiff face because of the defendant. We will elaborate everything which happened, and we have to do this in a chronological order. This is also a very like you may take this as a suggestion or advice whenever you start drafting a plaint. Just put all the events into chronological order on your notebook or wherever, like make notes in a chronological order and then convert it into plaint. So you will see that while we advance to the facts and we put the facts, everything over here is in chronological order, so that it is very clear cut even for the judge who is reading it. Okay, so this okay, so this was just a second. Okay. So this was about a consumer complaint, and we see that how we proceed to the facts. Now we are again seeing this suit for declaration and permanent mandatory injunction. The plaintiff's description, the property, whatever property is included, you have to give this property's description also, okay? Because as I mentioned, that you have to be very certain about what you are talking. Then we are seeing annexures here, okay? What these annexures actually are, that whatever document you are relying while you are drafting a plaint, you have to attach that document with the plaint. So we see that we are talking about a sale deed. In the declaration permanent, we are talking about sale deed. We have mentioned that the sale deed dated this and this on which we are relying is actually attached with this plaint as annexure P1. So it is nothing, but we are actually attaching all the documents with this plaint, and we are mentioning wherever required that this has been attached as annexure 1, then annexure 2, then annexure 3. So this is how we proceed. Now, okay, so we see that all the facts are mentioned, all the documents supporting it. Whenever we send the legal notice, it is given. Whenever, whatever we are giving, whatever documents we are relying, we are just using it. Now, there are 3-4 very important clauses which we discussed the last time. Is the clause of cause of action. Okay, so the cause of action, you have to say that on such and such date, the cause of action actually arose, and then you have to come on so then you have to come and state that how it is having jurisdiction. So there will be one paragraph where you will be stating that see, this court only has jurisdiction, territorial jurisdiction and pecuniary jurisdiction, because this is the amount involved and this is where the property is situated. Then as we saw that we also have to mention that what is the value of the suit, because it